For judgment, item number 30.
For reasons mentioned in the judgment, this writ petition is dismissed.
Right. May I, my lord? Lordship, I beg to mention item number 19, Lord. Lordship, we have a joint prayer. So we have received paper book only yesterday. So can you give us some time to read?
Lordship, it can be listed after 4 weeks for the paper book.
Heard Mr. Senti Younger, learned counsel for the petitioner. Also heard Mr. K.V. Angami, learned public prosecutor. It has been submitted at bar that that they have received the paper book of this case recently and needs some time to go through the same. And for that, an adjournment is prayed for today. The prayer is allowed. Let this matter be listed after 4 weeks.
Much obliged.
Kindly allow me to move on answer item. The criminal petition I have withdrawn on 20 March. I filed this morning. Since the evidence is fixed for tomorrow. If my lordship kindly allow.
Today?
Yes.
Today?
Yes.
Okay.
Please, Your Lordship, I beg to mention hearing item 38 on supplementary list. It's a fixed matter, but the leading counsel is engaged with the BIO Sumoto case before the principal seat to receive. So if this matter can be deferred.
Miss,
It's a close.
what is your name?
It's a close.
Case Guru, learned counsel for the petitioner. Also heard Mr. K.V. Angami, learned government counsel, as well as Miss Menoshino, learned counsel for respondent number 1. Learned counsel for the petitioner submits that the learned conducting counsel for the petitioner has to go to the principal seat in connection with some case, and therefore an adjournment is prayed for today. The counsel for the respondent side does not oppose the prayer, hence the prayer is allowed. When
After 3 weeks, Lordship.
let this matter be listed after 3 weeks.
Lordship, similar prayer for item 27. My apologies, Lordship. In item 38, there is an interim, Lordship.
Interim order shall continue till next day.
Item 27 as well.
Petitioner Lordship.
Your
On 23.
same order is for respondent number 3,
2 and 3, Lordship.
Miss School Learned Counsel for respondent number 2 and 3 prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. Miss Easter Learned Counsel for the petitioner does not oppose the prayer, hence the prayer is allowed.
If it can be listed on 15th of April, Lordship.
Let this matter be. Let this matter be listed on 15th, okay? On 15th of April.
Lordship. Nice, Lordship.
From the hearing item, Your Lordship, item 25, Your Lordship. This is a consensus prayer, Your Lordship. This matter may be listed after 2 weeks, Your Lordship.
Heard Miss Ina Holly, Learned Government Counsel, who prays for an adjournment due to personal difficulty. Learned Mr. What is your name? Who is for the, you have,
Your Lordship, I've taken the, this is a
she
consensus
submits that she has informed the counsel for the petitioner regarding her prayer for adjournment.
prayer. This is a consensus prayer, Your Lordship.
Weeks. Item 26, same order.
Lordship, item 1, Your Lordship. Your Lordship, I'm praying on behalf of my colleague, Your Lordship. She's indisposed, so this may kindly be refixed on Thursday, Your Lordship.
Who is your colleague?
AIM, Your Lordship. On 27, Your Lordship.
Heard Miss Ina Holly, London Government Council, who prays for an adjournment on the ground that conducting government advocate is indisposed. Also heard Mr. Supamwati Waling, Learned Counsel for the petitioner, who does not opposes the prayer, hence the same is allowed. Let this matter be listed
27th. Thursday, this Thursday.
on 27th of March 2023.
Your Lordship, I also make a mention for item 3 and 4, Your Lordship. Your Lordship, here I've sent the affidavit for vetting, Your Lordship, but it has not returned to me. So this matter may be listed after 2 weeks. Meanwhile, I'll file the affidavit within 1 week, Your Lordship.
Heard Mr. Lima Wapang, Learned Counsel for the petitioner. Also heard Ms. Ina Holly, Learned Government Counsel, who submits that the affidavit in opposition has been sent for vetting and she needs a week's time for filing the same. The counsel for the petitioner does not opposes the prayer. Prayer is allowed. You are for? Show the presence of, show his presence. Prayer is allowed. List accordingly.
After 2 weeks.
Your Lordship.
After 2 weeks.
After 2 weeks.
That will mention for unanswered matter, Lordship.
What is the matter?
Was a criminal petition, which is crossing of it.
Why? What is the urgency?
Parallel proceeding are going on in the way in the one.
No, but there is no urgency. For moving an unlisted item, there has to be some urgency. What is the urgency? Otherwise, it will be listed in its due course. If there is no urgency, it will be listed in its due course.
Obsession, Councillor.
That is the urgency. Okay. Okay.
Worship, I beg to mention item number 21. Kindly, this matter will come up after 2 weeks. I'm on behalf of 2 weeks. I'm on behalf of my senior, Wati Jamia.
Mr. What is your name?
Yes, Imli. 21.
Write his name. Learned Counsel for the petitioner. Learned Counsel submitting on behalf of Mr. Wati Zamir, Learned Counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. Also heard Ms. Ina Holly, Learned Government Counsel, as well as Mr. Joshua Sheki, Learned Counsel for respondent number 4, who do not have any objection to the prayer. Hence, the prayer is allowed. Let this matter be listed after
2 weeks.
2 weeks.
Oblige.
May I please, Your Lordship? Lordship, I beg to mention item number 18 from the hearing list. Your Lordship may be gracious if this matter may come up after A can say.
Heard Mr. So-and-so, Learned Counsel for the
Channel
Pichano, Learned. You are
for a
pub-
state, Lordship.
public prosecutor.
Lordship, on behalf of it,
Hence, the prayer is allowed. Let this matter be listed after 2 weeks.
Lordship, I beg to mention item number 2.
2.
Lordship, on behalf of people. Lordship, can you list this letter on 27 March 2025, Lordship?
Your Lordship, actually, I'm for the petitioner, appearing on behalf of my senior.
Yes.
Kindly
Okay. Heard Miss, what is your name?
Lorena,
Loreno, Learned Counsel for the petitioner. Also heard Miss
Pichano on behalf of Kipapong.
Pichano, submitting on behalf of
Kipapong.
Kipa Form, Learned Central Government Council,
Lordship, state.
Learned Government Council. Learned Counsel for the petitioner prays for 3 weeks' time for filing reply to the affidavit in opposition filed by the respondent side. The prayer is allowed. Let this matter be listed after 3 weeks.
I oblige, Lordship.
Please, Lordship. Lordship, I beg to mention hearing item number 23, Your Lordship. On behalf of the private respondent, Your Lordship, here the leading counsel of people police is supposed today, Your Lordship. So if this matter can come up after 2 weeks.
Lordship, no objection.
Heard Mr. M. Vero, Learned Counsel for the respondent. Also heard Miss
Ravi, secretary.
Learned
Ravi, secretary, Lordship.
K. Skuru, Learned Krovi.
Yes, Lordship.
Krovi Skuru, Learned Counsel for the petitioner. Learned Counsel for the respondent prays for an adjournment on the ground of has no objection. Stop. Hence, the prayer is allowed. Let this matter be listed after
2 weeks, Lordship.
3 weeks.
Interim may be extended.
The interim order shall continue till next day.
Much obliged.
Item
Appeal, first appeal.
Yes, Lordship. Lordship, all is the main respondent, that is respondent number 2 and 3, the district. Bifurcated by notification. Now the telecom department and the BSNL, they are now separate entity.
Okay,
The employee who is expired now was serving under the telecom department. And after the bifurcation, the that expired employee, he was transferred to BSNL.
okay, what is the prayer?
The prayer is that the widow of the deceased, they have filed the civil court praying for bifurcation of the pension. The district judge, they have
No,
bifurcated.
today, what is your prayer?
My prayer is I may be able to file an additional affidavit. Listing or reports certain
Okay, heard Mr. Younger.
Number 1.
What is your name?
P. Suren.
P. Soren, appearing on behalf of respondent number 1. Learned counsel for the appellant has prayed for allowing the appellant to file an additional affidavit to bring certain facts on record. The counsel for the respondent does not opposes the prayer, hence the same is allowed. Let this case be listed after 3 weeks.
From the supplementary cost list for motion item number 31.
Baptist Lordship,
Yes.
Lordship, before I take your Lordship to the impugn order, if I may be permitted to make a short submission on the facts, the case of the petitioner, and also the question of law involved, your Lordship.
Yes.
Now, your Lordship, based on a judgment passed in a civil proceeding in which the petitioner was not a party, the Deputy Commissioner Dimapur has issued an order, which is impugned in this petition, your Lordship, directing the revenue branch to make correction in the Jamabandi in respect of the petitioner's land, which is in peaceful possession of the petitioner since for the last 30 years, your Lordship. Now, Lordship, law is well settled that a judgment passed in a civil proceeding cannot be executed against a person who was not a party in that proceeding, your Lordship. Just on that question of law, your Lordship, may I just place the decision passed by this honorable court, your Lordship. That is the question of law involved, your Lordship. Para 9. Kotamia versus Para 9, your Lordship. May I read out? The law as regards to the question as to whether a judgment and degree of a civil court is binding upon a person who was not a party in the said civil court proceeding has been settled. The aforesaid question can also be looked from the point of view as to whether the judgment and degree passed by the learned civil court can be executed against a person who was not a party in the said civil proceeding. It is the settled position of law that any judgment and degree that may have been passed in a civil court cannot be executed against a person who was not a party to the said civil proceeding, your Lordship. Now, in my respectful submission, Your Lordship, the order of the Deputy Commissioner, Dimapur, amounts to executing against the petitioner a judgment passed in a civil proceeding to which the petitioner was not a party, Your Lordship. Now, Your Lordship, though right to property is no longer a fundamental right, Your Lordship, but it is a constitutional right protected under Article 300A of the Constitution of India.
Whose name was mutated?
The changes had been made. I'll be coming to the impugn order, Your Lordship.
Okay.
Now, in my
Land is your land.
land, a portion of the land is to be given to the other party who were, as per the judgment passed in the civil proceeding to which I was not a party.
Okay.
A portion of the land. I'll be coming to that impugn order, Your Lordship. Now, as such, if the order of the Deputy Commissioner, Your Lordship, is given effective, it will amount to, Your Lordship, depriving the petitioner of his right to property without the authority of law and without following the procedure established by law. And therefore, Your Lordship, it is also violative of Article 300A of the Constitution. Hence, Your Lordship, the petitioner is before this honorable court, Your Lordship. Now, coming to the impugn order, may I take Your Lordship to the impugn order? Page 21, read petition. And impugn order, Your Lordship, item number 31 to 35, there are 5 read petition, Your Lordship. This is the same, the common impugn order. They all are, petitioners are all agreed by this common order. Page 21. Page 21.
Yes.
Lordship has got it. This is the order passed by the Deputy Commissioner Dimapur, order dated 6 November
But
2020.
why have you preferred a writ petition
Your Lordship.
against a
Because now-
civil? You are not the party.
Yes, because my right has been affected. My right, my legal right to property, my right has been affected, Your Lordship.
Okay.
That is why, Your Lordship. Now, an aggrieved person can invoke the jurisdiction for violation of any fundamental constitutional or legal right, Your Lordship. Now, the right which has been guaranteed to me, constitutional right, protection has been given to me under Article 300A of the Constitution of India, Your Lordship. That has been affected, Your Lordship. So that is why the petitioner is before Your Lordship. Now, page 21, Your Lordship, may I read out? This order dated 6 November 2023. Whereas in the land dispute case titled Declaratory Suit number 6 and 7 of 2005 between Lordship, this is relevant, Your Lordship, Sri Vihole Khati and Angami Women's Farming Joint Farming Society, Dimapur, Nagaland. So basically, there was a dispute between two societies, Your Lordship, which was claim and counterclaim of an area.
This
measuring-
order is passed in which case?
Your Lordship,
Sums.
this is order, Your Lordship. I'll come to this. Lordship. I have submitted a representation pursuant to this, Your Lordship. May I take Your Lordship to page 26?
Yes.
Now, with reference to this office order dated such and such, the below mentioned, it was demarcated, including my name. A copy has been given to me. Copy to Your Lordship. May kindly come to copy to serial number 3 is the writ, is the petitioner in writ petition 42. Serial number 4 is the petitioner in writ petition 40. There's the present writ petition, Your Lordship,
This is the order for
for demarcation pursuant to the judgment. I will come to that. It will be more clear. Thereafter, your lordship, based on this, petitioner has submitted a representation.
No, this judgment was passed in which case?
This is declaratory suit 6 and 7,
Okay,
whereas a land dispute case titled declaratory suit 6 and 7.
okay, okay. Yes,
Now-
please.
Against this, your lordship, second para, an appeal was filed. Appeal also was, the appellate court has upheld. Now, pursuant to this, your lordship, this demarcation order was passed, joint survey demarcation, page 26. Am I clear, your lordship?
Yes.
So petitioner has a copy
No,
was
you
given.
could have challenged under Order 21, Rule 97.
No,
You are a stranger to that suit, civil suit 6 and 7.
Just because your lordship, in my respectful submission,
But can you come against an order of a civil court in a writ petition?
no, your lordship. This is order, your lordship. This is order.
This administration.
Be a quasi judicial order where someone is issued statements as taken, your lordship. This DC's order, your lordship, is purely
No,
on the
whether
administrative
the
fact.
DC, while passing an order in a declaratory suit, whether he exercises administrative powers or judicial powers.
Based on the judgment part.
This declaratory suit was pending before which court?
Before the civil judge, senior division.
Okay.
Thereafter, appeal was preferred before the district judge. Appeal also upheld the judgment order passed by the learned senior civil judge, your lordship. Now, if at all that judgment or degree is binding, it will be only between the parties, not the petitioner who was not as per the law laid down, your lordship, not the petitioner who was not a party to that proceeding. That is my case, your lordship. So accordingly, I have submitted a representation to the deputy commissioner. My representation is page 27, your lordship. If lordship may kindly read my representation, your lordship. Page 27.
So this order was passed. Whether any execution proceeding was.
If at all execution is to be done, it is to be done by the court, by the original court, your lordship. By the senior.
No execution proceeding.
No, your lordship. Now this is by the district, by the deputy commissioner.
Okay.
If execution, that is different, your lordship. Now in execution proceeding, then I could have raised some objection, but execution proceeding was not there. Execution proceeding will not be before deputy commissioner, your lordship. It will be before the original court.
Okay. So you are impugning this order dated 6th.
My representation is page 27. May I read out?
Yes. When you filed the representation?
My representation is 9/12/2024.
After the when you came to know about the judgment.
Yes, that demarcation order, the copy was served to me on November 2024. Then immediately I have submitted a representation. Now my representation was rejected by this order, page 30. DC has rejected my representation.
What you prayed in your representation?
My prayer, your lordship. Now, para 10, page 29, I'll just read out the relevant paragraph, your lordship. Para 10, 11, page 29. Lordship has got it.
Yes. There are 10 and 11.
Para 10. It is a well-settled principle of law that no one can be deprived of his right to property except as per procedure established by law. As such, making necessary correction, rectification, addition, subtraction in the Chita and Jamabandi record in respect of the District Judge Dimapur, which is not binding on me. And secondly, as per the order dated 6/11/2023 passed by a good office without giving me any notice or opportunity of hearing, and therefore not legally sustainable, cannot be accepted as a procedure established by law. Because this contention was that my representation was rejected. What has been stated here and above, it is therefore prayed that your good office may judicially consider this representation not to make any correction, rectification, addition, subtraction in the Chita and Jamabandi record in respect of the said plot of land. Now, this prayer has been rejected by
an order of civil court. You could have approached the civil court.
No, I have nothing to do with that proceeding, Your Lordship, because I was not a party.
But in execution,
Now, yes, if execution comes, then maybe I can appear before the court and I can raise objection.
okay, so
That is a
execution,
different procedure altogether. But this is by the deputy commissioner, not by a court.
so whether any direction was there to the deputy commissioner by the civil court? Any
No,
precept?
because no, direction that it has to be by way of an execution, Your Lordship.
Okay,
When any judgment and decree is passed, Your Lordship, it has to be by way of an execution. And rejection
okay.
order,
Your submission is that had there been an execution proceeding,
yes,
you could have appeared before the
yes,
executing court
yes.
and
And
raised your objections. there.
Objection, yes, Your Lordship.
But
Lordship is right.
in this case, without there being any execution proceeding, DC issued the order for
Yes,
mutation of
for
the
rectification of the area by which my area will be again, a portion of my land will be taken away, Your Lordship.
Okay.
So that is my case, Your Lordship. So my coming to my prayer, Your Lordship, my prayer is page 10. I'm praying for page 10, Your
Who is
Lordship.
appearing for the respondents? You have
No.
not made any private party.
Because the issue involved, Your Lordship, so far as the societies are concerned, Your Lordship, they are neither a necessary party nor a proper party in my respectful submission in this case, Your Lordship. Because the question of law involved is whether the petitioner who was not a party in the civil proceeding, like this thing, execution can be initiated against the petitioner based on the judgment passed in a civil proceeding in which petitioner was not a party. That is the only issue of Your Lordship. So in my respectful submission, Your Lordship, taking into consideration the question of law involved in this.
No, in a civil case, even if you are not a party, execution may be against in respect of a property which was subject matter of the suit.
Yeah.
And if you are aggrieved by the order and not a party to the suit, then you can approach civil court before the executing.
Before the execution court, Your Lordship, executing court, I can. That is also a different subject matter.
Okay.
But the issue here is different, Your Lordship.
Yes, Mr. Santam.
State respondent number 1 and 2. However, there is no private respondents.
It appears that this Viholi Khate, an Angami woman for
He is representing he is the president representing the society.
in whose favor the civil court
Yeah.
pass.
No,
the order.
against.
Then,
Because your lordship,
then
that,
in whose
that,
favor
that is why your lordship, I have not met him. But
Angami women
yes, Vihole
cooperate-
Khate and Angami Women's Farming Cooperative Society, Vihole Khate represents the society.
whether they are necessary parties.
No, in the course of the hearing, if it is necessary, your lordship, that they can be implemented, at any stage party can be made, your lordship, but whether the petition who was not a party to a civil.
Heard Mr. T.B. Jamir, London Counsel for the petitioner. Also heard Mr. L.T. Santam, Learned Additional AG, appearing for the state respondent. There are only two respondents
1 and 3.
in all cases, no?
Like state and in all cases.
State respondent. This application under Article 226 of the Constitution of India has been filed by the petitioner impugning the order dated 6/11/2023 passed by the Deputy Commissioner
And also later dated 18 to 2025, rejecting the representation of the petitioner.
as well as 6/11/2023. No,
Later dated annexure
no, before that. Impugning the order number REV-71/2017-D/2224-29 dated 6/11/2023
23.
passed by Learned. You are impugning the 23 order now. Why?
This order was issued, your lordship. I was not given a copy, but only that survey and demarcation copy was given to me,
Impugning the-
endorsed to me.
Impugning the so and so. What was the last name?
Filed by the petitioner impugning the order dated
Passed by the Deputy Commissioner.
Page 23.
Whereby a direction was issued for making corrections / rectification / addition / subtraction in the Chita and Jamabandi records
Of the petitioner.
involving the land of the petitioner. Learned Counsel for the petitioner submits that the impugn order dated 6 November 2023. No, thereafter the petitioner had filed a representation before the Deputy Commissioner.
Your lordship, it would be good if page 26 is mentioned. Thereafter, pursuant to that order, 6th November, the
Okay.
DC has issued this joint survey demarcation.
Learned Counsel for the petitioner submits that in pursuant to the aforesaid impugn order, the Deputy Commissioner on 25th of November 2024 issued order for joint survey / demarcation of the land involving the land of the petitioner.
A copy of which
and
was served?
And a copy of the said order was served on the petitioner. Stop. Thereafter, the petitioner, after approached the Deputy Commissioner Dimapur, Nagaland by filing a representation on 9/12/2024 for recalling the impugn order dated 6/11/2023 on the ground that the petitioner was a stranger to the civil
Proceedings.
suit, declaratory suit number 6 and 7, and therefore the judgment delivered in said suit is not binding on the petitioner. However, by order dated 18 February 2025, the prayer for the representation of the petitioner was rejected. Rejection order dated 18 February has also impugned the rejection order dated 18 February 2025. Has submitted that as the petitioner was not a party to the declaratory suit number 6 and 7 of 2005, on the basis of which the Deputy Commissioner has issued the impugn order, same is not binding on him.
Yes.
It is also submitted by learned counsel for the petitioner that no execution proceeding has been initiated
To the best of his knowledge.
as per the knowledge of the present petitioner, and hence he was compelled
And the prayer may be subject to the outcome of this petition. Prayer may be considered subject to the outcome of this.
Okay, your lordship, it's let the impugn order be subject to the outcome of the reputation. Okay, I concede.
okay. Issue notice to the respondents, since learned additional AG Mr. L.T. Sanctum has appeared for both the respondents. No formal notice need to be issued. However, requisite copies of the writ petitions should be furnished
In the course of the day.
to the learned, to the respondents during the course of the day. It is hereby. What was your submission?
Prayer for
Your
Notice
lordship,
petition.
since it is let us be fair, your lordship, let status quo as on today be maintained, your lordship.
your lordship, let the notice be sent first.
You'll
Prayer
be,
may be considered subject to the outcome of this writ petition. That is my submission.
Well, it's that to be fair, your
Let the
lordship.
state respondents file. Our
learned additional AG submits that prays for some time for filing a
Yes, ma'am.
affidavit in opposition. The prayer is allowed. Weeks.
Yes.
Oh, your lordship, that status quo we maintain or read petition, that will suffice.
Stop. On sub, it is hereby made clear that the impugn order shall be
Subject to the.
subject to the outcome of this writ petition, or list accordingly after following. In all the writ petitions, same order.
Same order. Same order.
The representation dates and everything serves.
In one. Oh, will furnish your lordship. The date to the state, no, your lordship. One,
Dates are
yeah,
different.
in one different. I will furnish.
In which case it is different.
Okay.
In item number 31 to 35, same order. In one case, the date would be different. Which date is different? You furnish
Date report.
in item number 34. Which date is different?
4th March, 4/3.
Your,
4/3,
your,
2025.
the impugn orders date.
No,
Or-
no, reply. Reply to the representation. Reply to the representation, GC's order, rejection.
Okay. In other cases, the date is 18th,
It's
18th March.
Except in 43,
Item number 34, instead of 18th March, it is
4th March,
4th March.
2024.
Clear?
From the supplementary cost list for admission, item number 36.
Yes. What is this? Registration certificate.
Was for the last occasion, Lalit PP, she sought some time to go through the act to assist this honorable court lodge.
Yes.
Your lordship, as per the act, your lordship, NVA, your lordship, registering authority may satisfy itself that the particulars contained in the application are true and that the vehicle complies with the requirement of this act. Of the rules met thereunder. Your lordship, the person himself has to come, has to go before the competent authority to renew the license. Now, in our present case, your lordship, the reason why I'm objecting is, your lordship,
No, the question is, first you have to be the owner.
yes, your lordship.
Thereafter, it has to be registered.
Yes, your lordship.
So first you have purchase the vehicle from its earlier owner,
Lodge,
and the process of registration is pending.
lodge. Transfer of ownership is pending, lodge.
Transfer of ownership. Transfer of ownership, where is the provision?
48, lodge, section 48.
Okay. What is the provision?
48, 50 lodges. Section 48 and 50 lodge.
What it says?
objection certificate, Lordship. Now, the owner of a motor vehicle, when applying for the assignment of a new registration mark, motor vehicle is to be effective in a state other than the state of its registration. The transfer, this is important, Lordship, the transfer of such vehicle when reporting the transfer under subsection 1 of section 50. So it has to be conjoined reading with 48 and 50, Lordship. Now the ball is in the court of the transfer, Lordship. Yeah, make an application in such form and in such manner as may be prescribed by the central government to the registering authority by which the vehicle was registered for the objection certificate, NOC, Lordship. To the effect that the registering authority has no objection for assigning a new registration mark to the vehicle, or as the case may be, for entering the particulars of the transfer of ownership in the certificate of registration. Certificate, no objection certificate. After once the certificate is obtained, it has to be transferred to the purchaser.
Who issues this certificate?
The authority, Lordship, the transfer department, Lordship. So the authority has to issue the certificate and the application has to be processed by the transfer, not the transferee. So it is the seller who should obtain the no objection certificate and hand over a copy of the certificate to the purchaser, Lordship. No, Lordship, only once it is done, the purchaser will initiate the proceeding for transfer of ownership, Lordship. May I continue, Lordship?
Yes.
To the effect that the registering authority has no objection for assigning a new registration mark to the vehicle, or the case may be for entering the particulars of the transfer of ownership in the certificate of registration. Then, Lordship, my name will be transferred in the registration certificate. Subsection 2. The registering authority shall, on receipt of an application under subsection 1, the registering authority now issue a receipt in such form as may be described by the central government. There is a format, Lordship, provided in the Act. Now they will issue this receipt, Lordship. 3. This is also important, Lordship. Subsection 3. On receipt of an application under subsection 1, the registering authority may, after making such inquiry and requiring the applicant to comply with such directions as it deems fit, and within 30 days to the of the receipt thereof, by order in writing, communicate to the applicant that he has granted or refused to grant the non-objection certificate within 30 days. Now, Lordship, what happens if after a lapse of 30 days, there's also a provision under this proviso, Lordship, provided that registering authority shall not refuse to grant the no objection certificate unless it has recorded in writing the reasons for doing so, and a copy of the same has been communicated to the applicant.
But in this case, these steps were not taken.
Not taken, Lordship. Now what happens, Lordship?
Seller did not approach the DTO, the registry, this motor.
Lordship, for all fairness, a certificate was obtained in terms of section 48. A certificate was obtained.
But in the name of
someone else, by the name Mr. Abdul, Lordship. Now, in the present case, Lordship, the present applicant Lordship. Now, what happens, Lordship? In the absence of such certificate, or if such certificate cannot be obtained within the stipulated period of time, what is the penalty, Lordship? Section 50 comes to rescue, Lordship. And section 50 has to be conjointly read with section 177, Lordship. Now, section 50 provides that a penalty of ₹100 will be imposed. 100 rupees.
Which provision?
Section 50, Lordship, subsection 3. Subsection 2 is irrelevant in my case, Lordship. So subsection 3 will be relevant for my case, Lordship. Now, section 50, subsection 3. May I read the Lordship?
Yes.
If the transferor or the transferee fails to report to the registering authority the fact of transfer within the period specified in clause A or B of subsection 1, as the case may be. So it refers to section 50, Lordship. Hereinafter, in this section referred to as the other person fails to make such application within the periods prescribed, the registering authority may, having regard to the circumstances of the case, require the transferor or the transferee or the other person, as the case may be, to pay in lieu of any action that may be taken against him under section 177, which shall amount to an amount not exceeding 100 rupees as may be prescribed under subsection 5. Now, failure to pay this 100 rupees, Lordship, section 177 will come into play, Lordship. And 177 has prescribed for rupees 500, Lordship. If I fail to pay the 100 rupees, under 177 will come into play and have to pay rupees 500, Lordship. That is the only penalty as far as this provisions, as far as this act is concerned, Lordship. Now, what remains, Lordship? Yes, rightly or wrongly, Lordship, apparently what in this, as far as this case is concerned, the transferor who has the obligation, the burden to obtain a copy of the certificate, Lordship, he has failed to. Only once the transferor obtains the certificate, I will initiate the proceedings to transfer the ownership under section 50 of the Act, Lordship. Burden passed on the transferor in the first place. Once I obtain the certificate, it is my duty, my responsibility to approach the appropriate authority to get my name registered or transferred under provision of section 50, Lordship. Now, what 177 says, Lordship? Since this section 50, subsection 3 talks about 177, if I may be allowed to refer to. Lordship, as far as the provision is
And then you
concerned,
can continue without registration.
that does not encourage someone not to get it registered, Lordship. And as far as the petition is concerned, I was ignorant of this fact, Lordship. In fact, Lordship, the transferor should have obtained the certificate as required under section 48. Now coming to 177. This is chapter 13, Lordship, chapter 13 of the Act. Offenses, penalties, and procedure.
Okay.
Section 177. General provision for punishment of offenses, Lordship. General provision. Whoever contravenes, Lordship, any provision of this Act or any rule, regulation, or notification made thereunder shall, if no penalty is provided for the offense, though penalty is very much provided in the section 50, subsection 3, even otherwise, Lordship, be punishable for the first offense with a fine which may extend to 500 rupees. The first offender, Lordship, the first offender. At the most, as far as my client is concerned, she shall be termed as the first offender. At the most.
Assuming you are.
Assuming, but not affirmative.
Then you pay 500 rupees. Thereafter, what will happen?
I'll proceed, Lordship. I'll have to process for
then
necessary.
there is no need for transferring the.
Of course,
Then can you continue with the earlier registration?
Lordship, as far as 177 is concerned,
A vehicle has to be registered in the name of the owner.
section 48 and 50, Lordship, 48 and 50. Lordship. Why 48, Lordship? No objection certificate. This is the first requirement I have to fulfill.
No necessity of registration. You are saying that if it is not registered in your name,
Lordship.
even after transfer,
Lordship.
then you can continue with such unregistered vehicle by
Lordship,
paying 500 under
Lordship,
176.
respectful before this note report, I do not concede to that, Lordship. I do not concede to that. In fact, Lordship,
What is
letter
39,
friend has,
section 39?
Lordship. 39, Lordship. Necessity for registration of course, Lordship. May I read it, Lordship?
Yes.
No person shall drive any motor vehicle or no owner of a motor vehicle shall hold or permit the vehicle to be driven in any public place or in any other place unless the vehicle is registered.
So this vehicle is otherwise a registered vehicle,
It's a registered vehicle, Lord.
registered in the name of Manoj Kumar.
Exactly, Lordship. Exactly, Lordship. It is a registered vehicle and the registration in the month of December 2023, Lord.
And registration was renewed or not?
It was renewed, and which is why my learned friend has produced a renewal report, Lordship.
And since my objection is that, since it has been renewed in the same person's name, Your Lordship, after the transfer has been done, Your Lordship, according to the petitioner, like all the RC, everything has been handed over to the petitioner. Now, when all the title and deed has been given to the petitioner, how come, Your Lordship, again on the day of renewal, it was renewed in the name of Manoj Kumar? Your Lordship, that is to be considered. And another thing, Your Lordship, as per section 48 is concerned, Your Lordship, no objection certificate. As rightly pointed out, Your Lordship, there's no objection certificate being given, Your Lordship, to one Abdul, Your Lordship. And now, if you can kindly come to 8, Your Lordship. 8, page 37 of the, no objection.
Yes.
Page 37. It says period of stay in the
Page
state.
37 of the application.
Yes, Your Lordship, of the application of the writ petition, Your Lordship. Now, the petitioner is stating that this does not have any relevance, Your Lordship. I mean, like, since sale deed has already been executed. But Your Lordship, if you can kindly see 37, page 37.
Yes.
No.
Yes.
Page 37, paragraph 8, I mean, like serial 8, Your Lordship. Period of stay in the state, 2008, Your Lordship. So no objection certificate has already been given to this Abdul Qayyum, and the period of stay in the state should be from the 2008, Your Lordship. So objection certificate has already been given, Your Lordship. Now I don't know from this henceforth what happens, that I don't know, Your Lordship. However, Your Lordship, you got it, Your Lordship.
This no objection certificate to Abdul Qayyum
Yes.
was given when?
Your Lordship said the period of stay, that is not given, Your Lordship, but the period of stay. Because this, the vehicle in question is registered in Delhi, Your Lordship. And if it is to be used in another state, there should be a no objection certificate informing the competent authority, Your Lordship. The provision is very clear in that regard, Your Lordship. Now, if you go to serial 8, Your Lord, period of stay in the state, 2008.
What it means?
So it's presumed that like the objection has already been, no objection certificate has already been obtained in favor of Abdul Kalam, that this vehicle, because it says that this person resides in the jurisdiction of the registering authority of the state of Nagaland. Your Lordship, I intend to sell the vehicle to so-and-so who resides in the jurisdiction of the registering authority of the state of Nagaland, Your Lordship. And the period of stay is starting from 2008. It was registered
No
in
objection
2008.
certificate has to be obtained before transfer or after
Yes.
transfer.
Your Lordship.
After selling the vehicle, you have to obtain no objection
Your Lordship, we have to be very clear on one clear in this regard. One thing, before Your Lordship, the vehicle is registered in Delhi, Your Lordship. If I want to let the vehicle be used in another state, Your Lordship, there should be an obtain of no objection certificate, Your Lordship. Then only the vehicle can be used in another state, Your Lordship.
Where is that provision?
Yes, Your Lordship, Your Lordship, provision, Your Lordship, 40. If you can kindly see 47, Your Lordship.
Yes. What section?
47, Your Lordship. When motor vehicle registered in one state has been kept in unregistered for a period exceeding 12 months, the owner of the vehicle shall within a period, such period in such form containing such particulars as prescribed by the central government apply to the registering authority within whose jurisdiction the vehicle then is for the assignment of a new registration mark and shall present the certificate of registration to the registering authority, provided that the application under this subsection shall be accompanied by the no objection certificate obtained under section.
But it was not registered.
Yes, Your Lordship.
The 47 was not complied with in this case.
Yes, Your Lordship. That's why, Your Lordship, for this purpose, no objection was given to one Abdul, Your Lordship. And for the period of stay is starting from 2008, Your Lordship. Now, from this henceforth, we don't have any record, Your Lordship. However, coming to our case, Your Lordship, in case, Your Lordship, my only objection is that the petitioner has already given out, Your Lordship, the title, the RC, everything to the petitioner by executing a sale deed on March 2003. And it was the validity of that RC is still December 2023, Your Lordship. Now, after obtaining all the title and deeds, Lordship, my question remains is how come the vehicle was again renewed in the person in the name of that original person, Your Lordship, the original owner? Because while renewing, Your Lordship, the person concerned has to come to register.
Where is the renewal?
Lordship, I have already read it in 44, Your Lordship, production of a vehicle at the time of registration. Your Lordship, 44, the registering authority shall, before proceeding to register a motor vehicle or renew the certificate of registration.
No, where is the proof that the RC was renewed?
That's why, that was the dispute renewed, Your Lordship. On the last occasion, I submitted, Your Lordship.
The CD is with you. Whether it mentions about
Yes, Your Lordship, it mentions the date of the renewal, Your Lordship.
but
Orange tick, Your Lordship, orange tick.
it mentions date of registration as 12/21/12.
Name of the registered owner, Manat Kumar Chaudhary. Date of registered, Your Lordship, 21/12/2023.
The registration number remains same. DL2CA. Is there any change in registration number?
There's no dispute with regard to registration or renewal, Lordship. Registration in the name of Manoj Kumar and it was renewed in the name of Manoj Kumar, Lordship. There's no dispute. My learned friend has stated that there's a dispute. No dispute as such, Lordship. I consider the fact.
But before renewal, he had already sold it to you.
Yes, Lordship. I agree that.
Then
Lordship.
if he has sold the vehicle to you in the month of March,
Lordship.
then why it
I
was
have technically
renewed?
mentioned in my petition that it was under process, Lordship. It was under process. And the purchaser being an ignorant of the facts of the provisions under the act, it was delayed, Lordship. Otherwise, Lordship, if your Lordship may kindly appreciate, even in the charge, it is clearly reflected, there was a direction issued to all the Aussies in the entire country, Lordship, as regard to the present vehicle in question, whether there is any offense committed while using the vehicle, or if there is any adverse remark against the vehicle. Charge of Lordship, and in fact, Lordship, with due respect, it is my respectful submission that it is deviating from the main issue, Lordship. And as far as this motor vehicle act is concerned, Lordship, this is altogether a different proceeding, Lordship. if I fail to comply all those procedures, Lordship, unless there is any adverse remark against me, Lordship,
Do
it
you,
has to be before the
do you have to say anything
No, no,
regarding the registered sale deed?
no, your
Sale
lordship.
deed by which he has purchased.
No, no, your lordship, I don't have any objection.
and
to
sealed
that.
is
But my,
as per the requirement of the Transfer of Property Act, Lordship.
my only objection is that I find the discrepancies there only. My submission may be recorded and everything. I leave it to the wisdom of this court, your lordship. However, your lordship, everyone has should be given a right to submit and there's a discrepancies in this. That's why I'm submitting before this honorable court. The honorable court may record my submission and the rest it be to the wisdom of the court, your lordship. I think there is nothing bar to make our submission, your lordship. I've just pointed out that, your lordship, how can it be renewed in that name? The petitioner is saying that, okay,
Nobody is prohibiting you from making submission.
petitioner is saying that it is out of context and so and so.
He will,
It's not right, no, it should have been taken by another person. I think is it not right, your lordship? I think everyone has a fair submission. Everyone should be given an opportunity of fair submission. It's not that now at the back, he's stating they should be taken by another PP. Is it right? Your
no,
lordship?
he's not saying so.
No, at the back, he's saying the other person. It's not good, your lordship. That is not an impression. We are to defend the case and there's a discrepancy I see in my humble opinion, in my humble view.
Yes,
I'm
yes.
raising that, that's
Yes.
it, your lordship. The
You-
rest is up to the court. Your
You
lordship,
have
to
a,
decide.
you have a right as well as duty to do so.
Yes, that's it. Nothing personal, your lordship. It's up to the court to decide. I've submitted, that's it. My
Lordship, the
submission may be recorded.
Inquiry officer has conducted its investigation.
Heard Mr. Muazzamir, learned counsel for the petitioner. Also heard Ms. Livika, learned.
Fair.
What is not fair?
At the back, I'm making a submission and he's saying it should have been taken by other PP. Is it right, your lordship? That's so unfair.
Lordship, that's not proper.
I'm not-
No, Ms.
She's not
Livika,
supposed to make such submission, Lordship.
Ms. Livika, what happens on
She's not supposed to, and she should not take it personal.
behind the
Lordship.
back of the court?
Taking a-
You should be able to bear with that. He has not made any such submission while making his submission
Yes.
before the court.
Exactly, Lordship.
That's
Thank
it
you,
for you,
Lordship.
lordship.
Okay, heard Mr. Muazzamir, learned counsel for the petitioner. Also heard Ms. Livika, learned public prosecutor. On Thursday, that is on 27th of March. I'm keeping the case diary with me. Case diary, I'm keeping it with me. Let it be 27th March.
Lordship. Lordship.
One file is still very long.
Okay.
From the supplementary cost list for motion item number 39, criminal petition number 10 of 2025.
What is this?
The petition is filed under 5 of the BNSS out of the 3 for causing the ground is, my lord, the complainant have admitted that he have filed a fire based on the false information given by his daughter. And notice that even the victim have stated that out of fear for her parents, she have stated that she was sexually abused by the accused.
Where is that?
I have annexed page 73, annex 12. Is the statement of the victim in our deposition.
Page 70.
Annex 11, page 71 is the deposition of the complainant. PW1.
Whether charge sheet has been filed
Yes, is at a state of evidence.
and
Some-
evidence is also recorded.
Yes, my lord. I'm annexing the his recorded statement given in his evidence.
At this stage, you are coming for quashing of FIR.
Yes, my lord.
You are otherwise facing trial.
Yes, my lord.
Then
The issue is since the complainant has stated in his in the evidence states, so there is no case against him
no,
now.
let the trial court decide. This is not a case for in the midst of trial. You have not approached this court at the earliest occasion for quashing of FIR. In the midst of trial, when one of the witness has exonerated you,
Well, since the victim and the complainant have stated in the evidence, I have a better ground to approach this honorable court. If I come before the evidence is given by the complainant and the victim,
how many witnesses are there?
uh,
Listed witnesses.
two remain, Your Honor.
Total, how many were listed?
Eight witnesses.
Out of 8, 6 have been examined.
Yes, six, I think.
6 have been examined.
Yes, madam.
Only 2 remaining.
Yes, madam.
This is not a case for exercising inherent jurisdiction, prima facie. You have to wait till, because this trial has progressed. Otherwise, everybody will approach High Court in the midst of trial that 2 of the witnesses have not
Lordship. Please, Lordship, with regard to respondent number 4 and 5, on the last occasion in IF 42, we have served a notice through paper publication. However, the respondent number 4 and 5 failed to appear. So if you could kindly proceed the matter without respondent number 4 and 5.
Where is the paper publication?
It's in IF 42.
Whether
Page number 7.
this IA is pending? Okay. Whether any what for this IA was filed?
For affidavit for service.
Why separate IA was filed?
On 10th of November last year.
No, why separate IA was filed? No, this IA was for condoning the delay,
Yes,
condonation of the delay. In that notice was issued. But here in the, after condonation of the delay in main appeal, you have to take fresh steps for issuance of notice.
So in the case, kindly allow us to take steps to paper publication.
Okay. Miss, what is your name?
Tondi.
T.
HONDI.
Heard Miss Tondi, learned counsel for the appellant. Also heard Mr. M. Vero, learned counsel for respondent number.
Let me respond on behalf of PN Sharma.
Insurance company has not appeared. No, they are the insurance company. Learned counsel for respondent number 1 and 2. Yes. 1, 2, and 3. Against which respondent you will take steps by paper publication?
4.5. Respondent number 4.5.
4 and 5 seems to be related.
5 and 6.
5 and 6. Yes. You are for 1, 2, 3, and 4. Heard Mr. Vero appearing for respondent number 1, 2, 3, and 4. It appears from office note dated 27/2/2025 that the notice is issued to respondent number 5 and 6 have not returned back. Stop. Learned counsel. You will take steps through paper. Learned counsel for the petitioner has prayed for allowing the learned counsel for the appellant has prayed for allowing the why applicant appellant has prayed for allowing the appellant to take steps for issuance of notice upon respondent number 5 and 6 through substituted mode of paper publication by publishing the notice in a local newspaper. The prayer is allowed. The petitioner shall take steps for issuance of notice through paper publication within 7 days from the date of this order, showing the date of appearance in the notice to be published in the newspaper as 30th of April. 30th of April. So, list after 4 weeks.
Much obliged.
For orders, item numbers 6 to 12.
Please, Your Lordship. Your Lordship, the union respondents, they have already issued the check to the respective deputy commissioners of the district and by the check dated 26/12/2024, my lords. My lord, and affidavit has also been filed by the union. My lord, in their affidavit, all these checks are annexed. Despite this, check which has been issued to the respective DCs in the state connected with this contempt petitions, Your Lordship. The check dated 26/12/2024 is not yet released, Your Lordship, to the petitioners. All the related cases listed here, Your Lordship, in these contempt petitions, checks have been issued for all the respective Ministry of Road Transport and Highways, Your Lordship.
This is in respect of some
Your Lordship, this is for compensation in different districts. Compensation for the damages by the road construction which was carried out years back. My lord, the judgment is at page 141, annexure A of my contempt petition.
who is not following the order? Deputy commissioners.
No, Your Lordship. The respondent number 1, that is the chief secretary.
State.
Yes, Your Lordship. The respondent number 3, that is the commissioner and secretary.
State has not released the compensation.
Yes, Your Lordship. As far as the union is concerned, they have even issued a check to the respective DCs on 26th of December 2024 and has placed the same on record by filing the affidavit, Your Lordship. It is the state that is not releasing the money.
Yes, Mr. Sankam.
Yes, please, Your Lordship, I pray that Your Lordship may be pleased. Number 13 of 2024. COB 13 of 2024. 350.
Yes.
I read my note. Second last there. Admittedly, the damage caused to the lands and properties have been already assessed by conducting a joint survey, and even the quantum of the compensation amount to be paid has also been determined under the leadership and supervisions of the deputy commissioner concerned. As such, the state government shall make the first move by submitting a proposal along with the assessment made by to the central government / the ministry concerned, and on receipt of the same, the latter shall initiate the process for allocation of fund and release of the same to the state government who then shall disperse the same through the deputy commissioner of the district concerned to the genuine landowners whose lands, properties, standing crops and trees, etc., have been damaged or destroyed during the construction of the road. The whole exercise should be completed within a reasonable time, but not beyond 6 months from the date of this judgment and order. This was passed in BIL 9 of 2022.
Yes.
Here, what I'm trying to see. Make my submission very specifically is that accordingly, the state respondents have written to the ministry concerned, MR and TH, pray for the release of the of fund to be dispersed to the affected landowners. However, my lord, may kindly turn to running page 456 in COP 22/2024.
456 page.
$456.
Which may go so. Yes.
Yeah.
Yes.
May I read my law?
Yes.
Please refer to your letter dated 21/12/2023 regarding recovery of ₹60 crore.94 from a separate funding/source instead of from the agency charges payable to the state government of Nagaland by the ministry. The works of two laning of Longlen Changtungya, Mon Tamlu Merango, Head Putro and Chakapama Zanagoto Road with a total length of 329 kilometers in the state of Nagaland was sanctioned by the Ministry for Development under SARTP and NE scheme and was entrusted to State PWD for execution. However, due to poor implementation/handling of the project by the State PWD, compensation of ₹60.94 crore towards damage Hague District was passed by the Honorable Court of GAUHATI, KOHIMA bench on 30th January 2023. Moreover, Ministry sanctioned the same amount upfront on 27/10/2023, subjected to recovery from agency charges payable to the state to the Nagaland High Court Koihima bench white order dated 21/11/2023 directed the state government of Nagaland and MRTNH to make payment of ₹60.5 crore as damage compensation for the remaining district Zenabuto, Mokokchung, Kohima. It has been requested write your letter under reference to reconsider to sanction the amount of 60.5 crore for making upfront payment in view of the board's order. I request the state government to kindly suitably consider the matter at your level to comply with order of the honorable court in a time-bound manner. To which the Lordship may be pleased to come to page 457. That is Annexure A. May I read my law?
Yes.
To shall so, subject legal notice, reference such and such. Sir, in reference to the subject and letter cited above, I am directed to convey that this office in compliance of the Honorable compliance of the judgment on order dated 21/11/2023, passed by the Honorable High Court in WBC number such and such has written to the Secretary, Ministry of Road Transport and Highway, white letter number such and such dated 28/2/2024, copy enclosed, for compliance to the directions of the Honorable Court order for timely payment of damage compensation. Here, my lord, state is only agency, and the employer is the TNH. So state is not supposed to allocation of fund. However, when nothing was mentioned in the judgment on order passed in the WBC 9, PIL 9, the fund first should be allocated by the ministry concerned. Thereafter, after receiving the allocation of fund, the state government through deputy commissioner concerned will release the fund. However, the ministry has written to the state government, responded, directing that the funds so allocated will be recovered from the state agency charges, which was never reflected in the judgment law. That is my brain.
Lordship, in the building case, the judgment was passed in the month of November 2023 by this uniform. And Lordship,
Who is appearing for the Ministry of Road Transport?
for a ministry, my learner, please.
Now.
Lordship, the issue is like this, Lordship. Lordship, the judgment was passed in the month of November 2023.
Who has submitted the affidavit that money has already been paid?
The mortgage.
Contention made by them in the affidavit that
I've yet to receive the affidavit by the CHC.
Your Lordship, the
very
issue that has been raised by the learned AG, additional AG, my lord, that is an issue between the state and the union. When the money has already been sanctioned and the checks has been issued to respective DCs, my
where
lord.
is the affidavit?
Your Lordship,
Lordship, it condemned 13 of 2024.
yes, Your Lordship.
Condemned 13 of 2024.
Page?
My lord,
There is reflection in the order. You have to respond to that, Mr. Sanktam. When the Ministry of Road and Transport is saying that they have paid the money.
My lord, that is for
Well,
payment. However, the entire
Judge.
allocation of fund has to be recovered from the state agency charges.
No, that is not the issue.
That is an issue which is residual between the state government and the importing.
When the state respondent is only an implementing agency. We are not the employer.
No, where the money has been paid.
Lordship, in the affidavit, Lordship, may kindly come to page number page 12. Page 12. Lordship, this is a letter dated 24/12/2024. By this letter, the immortgage they already sanctioned the amount.
Page 20.
Page 12.
Annexure 3.
Annexure 3. This is a sanctioning letter.
We were never communicated about the sanction of the said amount.
Your worship, this letter was
This
addressed to the
letter is
commissioner secretary.
addressed to you.
This letter is addressed to him, worship.
This
How we
letter
cannot,
is,
how we can see that this is not aware.
this letter is addressed to you.
Exactly. And thereafter, worship, on 31st December, that is the next annexure, page 13, annexure 4. This is a letter releasing the check to the Deputy Commissioner Mo. And subsequently,
What was the compensation amount which was directed? The court's order?
60,
All the checks that has been issued, it's specifically as per the direction of the government of no dispute with that.
60 crores, 60.05 crores, Worship.
That was the total amount.
Total amount in respect of 4 districts.
So the,
No, your lordship, that is exclusively for pet district.
No.
exclusively
No,
for,
that is different, your lordship. Tax case is different.
For PEG, it was 60.94 crores, Worship. That you have already released the amount, Worship. In respect of the present content, which is pending before this Honorable Court, the amount is 60.05, Worship.
60 crores, 5 lakhs, 45,070 rupees.
this affidavit says that money has already been paid to you.
Sanctioned. Now the state government is withholding the whole amount, the payment. So if it is a hit case where the content proceeding has to be initiated with the state official.
The affidavit being filed by the MRTA PNH, we are yet to receive the affidavit. However, in the annexure 3, your lordship, be allowed to read the first paragraph. I'm directed to refer to
No.
ministries.
You,
I'm for respondent number 4.
let us,
In that case, within a week's time.
we will
the victim
fix
report.
short date. Because this has been addressed to your officers only.
And feeling which the content proceeding may be initiated against the.
2 weeks time it is done. 2 weeks time.
I mean, the meantime, amortized.
My lord, we understand the difficulties of our learned friends representing the state also, my lord. But in a similarly situated case, in PET case, they have raised the same issue that from the state expenses, agency charges should not be recovered by the union, but still money has already been released to the public. What is the difference between that case and our
Yes.
cases, your lordship?
Here, on perusal of the affidavit, it appears that road transport has released that money only in person to the court's order
My lord.
for payment of compensation. That has to be released.
My lord, may kindly permit me to read. In the annexure 3, running page 12 of the affidavit in opposition filed by the CJSC. In all letters, subject to the condition that the said amount be recovered from the overall agency charges payable to the state.
Where are you reading? Yes.
My lord,
So
the ones in
mention
bold
of
letter, the first
the
paragraph,
judgment
your
amount.
lordship. In bold letters, subject to the condition that the state amount be recovered from overall agency charges payable to state government of Nagaland, which is an issue between them and doesn't concern us, my lord.
Respondent number 1. Lordship, in the content petition, the
Content proceeding.
the sanctioned amount has been sanctioned to the respondent number 3, who is the commissioner secretary. Who is the respondent number 3 in the present content petition.
He is an officer subordinate to you. Chief Secretary can say that what is within the knowledge of commissioner is not within his knowledge.
The Lordship, because the affidavit filed by the Union of India is being given to us only this morning. So
But the letter is addressed to your.
So we will ascertain that whether this letter actually has been received by us or not. We will ascertain that. And besides that, your lordship.
No, you go through, you take instructions and then, but what appears from records is that in pursuant to the directions of this court, the Ministry of Road and Transport has already released the money
Yes.
with some conditions. That conditions are in between you, state government, and the ministry.
Yes.
But this money is for payment of compensation to the affected persons.
We are ready to comply. However,
Then comply.
because of this later written to the
Whether a copy of affidavit was not furnished to you.
no, no.
You have to furnish.
Yes, your lordship.
Heard.
Even otherwise, it is just their own document, my lord, which
Yeah.
they will be sealed in the affidavit also.
It is their own document. You cannot take this plea that what commissioner knows, chief secretary does not know.
My lord, the concerned deputy commissioner is never impleted. It's not impleted. As
It's impleted, your lordship.
Heard, Mr. Who is the petitioner here?
Yes, your lordship, in the contempt petition number 13, I'm for the petitioners, my lord.
13. Heard.
in COP 22/2024, deputy commissioner concern is not impleted. Because the sanction was recorded as per this letter annexure 4, page 13. It is addressed to the deputy commissioner about the release of check for damage compensation.
The DCs are willing to release, actually, my lord, but it is the the state respondents who are not willing. My lord.
No, but still you have to make them parties. If they are not really, they are the person who have to release it.
No, Lordship, the check is with the DC, but you're waiting for the direction from the state government. to release the money.
Concerned deputy commissioner may be impleted.
My lord, money is already there, so we may not complicate the matter
Yes,
further with.
this implement will take and
Implement, they can just,
you respond to this affidavit.
Well,
Respond to this letter. Heard Mr. Joshua Sheki and the counsel for the. There has to be separate orders in.
From item number 6 to 13, these are listed as analogous.
6 to 12. Yes, 7 to 2. 6 to 12.
6 to 12.
Heard Mr. Joshua, 6 to 12 common law. Heard Mr. Joshua Sheki, learned counsel for the petitioner in COP within bracket C 13/2024. Also heard Mr. Lima Wapang, learned counsel for the petitioners in other 5 from 7 to 12.
7 to 12.
Also heard Mr. L.T. Santang, learned additional AG appearing for respondent number 3 and 5. Stop. Mr. N. Angami, learned senior government counsel appearing for respondent number 1. Mr. Z. Ingoli appearing for central government standing council appearing for respondent appearing for the
Ministry of Road Transport.
Ministry of Road Transport and Highways. Mr. Moazamir appearing for respondent number 6 and 7. Mr. V. Zumomi appearing for respondent number 4. Learned counsel for the petitioner has submitted that The respondent number 6. Ministry of Road Transport is respondent number 8, that is Ministry of Road Transport and Highways, have filed an affidavit in opposition on 14th of February 2024, wherein amount of rupees 60.05 crores to be paid in pursuant to the directions of this court. Within bracket order dated 7/2/2024 in PL 1/2023 has already been sanctioned to the where is the where is the amount that mentioned that it has been disbursed to the
My lord, it is at annexure 3, page 12 of the affidavit filed by the union, your lordship. My lord, in the first paragraph, my lord is in the same page 12, annexure 3. First paragraph, 1, 2, 3, 4, from the bottom fourth line, 60 crores, 5 lakhs, 45,070 rupees.
Kalika.
Learned counsel for the petitioner has submitted that the respondent number 8, that is the Ministry of Road Transport and Highways, have filed an affidavit in opposition on 4th February 2024, wherein they have contended that the compensation amount of rupees
That
60.04
for payment of compensation amount of rupees 60.05 crores, comma, administrative approval, technical approval, and financial sanction has already been conveyed to where it is mentioned that it has been conveyed to the state government. Conveyed and
No mention is made, my lord. In
no,
this declaration.
thereafter, and the and the two different
The sanction
No,
letter
no, no.
December 2024.
You respond to it.
Your Lordship, I just wanted to make one clarification here. Who sanctioned this particular letter is also cannot be seen in the letter.
No signature.
It cannot be seen. Who sanctioned this letter? It is of course addressed to the Commissioner Secretary, no doubt. But who sanctioned it, Your Lordship, as per this? Affidavit they have filed?
No, you take instructions and respond within 2 weeks.
Lordship.
You have prayed for 2 weeks time.
amount of rupees 60.05 crores, administrative approval and the
Administrative approval, comma, technical approval and financial sanction has been accorded for payment of damage compensation on the basis of this court's order. It is also submitted by learned counsel for the petitioner that the checks checks for the check for damage compensation. No, where is that statement that checks are released?
Your Lordship, the checks are also annexed. In the annexures, my lord. The check released to Deputy Commissioner Mon is dated 31/12/2024. At page 15, my lord.
Who has released these checks?
Lordship, by the Ministry of Shipping, Road Transport and Highways.
It has also been submitted that the checks for payment of damage compensation in pursuant to the direction of this court has also been released to the respective deputy commissioners. Stop. Learned additional AG, Mr. L.T. Sanktam, has submitted that he has not received the copy of affidavit in opposition filed by the respondent number 8 in this case, and praised for furnishing a copy of the same, as well as some time for taking necessary instructions in this regard. The prayer is allowed.
To this extent,
The learned Central Government Standing Council shall furnish the copy of the affidavit to the learned councils for respondent number 3, 5, 1 and 4. You also furnish to them. Let this matter be listed after
2 weeks.
2 weeks. Upon the date. Let them get confident.
My lord, been quite some time, so at least on the next date, some effective orders are expected to be passed.
Let them respond.
If bound with a positive response to the next day.
They may come up with.
Your Lordship, we will definitely comply with the.
No, this is a contempt proceeding. If they don't comply, they will face the consequences.
My lord.
Thank you.
Bless you, lord.
For orders, item numbers 13 to 16.
Your number?
Please, Your Lordship.
Yes.
Lordship, in item number 13, Your Lordship, notice to respondent number 1 was returned as answer of Your Lordship. So we have been trying to trace the new address of the respondent number 1. So on the last occasion, Your Lordship, by order dated, these matters were all clubbed together, Lordship, because the petitioner in item number 14 and 15. Lordship, the petitioner in item number 14 and 15 is the respondent number 1 in item number 13, Lordship. So these items are clubbed together, and this morning the counsel for the petitioner in item number 14 and 15 has furnished me the new address of the respondent number 1.
Has furnished?
Yes, today, this morning. So I may be allowed some time to take new steps, Your Lordship, upon the respondent number
When
1.
the petitioners are same, the council has already appeared in the same council. Who is appearing for?
The leading counsel is IRC, Lordship, from GAUHATI.
You are appearing for Rajdeep Bhuya.
In 14 and 15, Lordship, the petitioner.
You can accept notice in 13 instead of sending notice to the.
Lordship, I'm for the petitioner in 13, Your Lordship.
In 13?
Yes, it seems that they don't have any instruction regarding item 13 to appear.
You
As
take
yet.
instructions.
Taking take notice through this post 80, your lordship.
To
Through this post 80, your lordship.
registered post. No, why it is required? When you are appearing, since you are appearing, you take instruction. If he refuses, we will proceed ex parte.
Item number 14, criminal petition 18 of 2023, we have already withdrawn our names from the case lodge, or we needed and from the conference lodge. Maybe I will request the case lodge.
Item number 14. Heard Miss, what is your name?
Esther, your lordship.
Yes, heard Miss Esther Learned in item number 13. Learned counsel for the petitioner who submits that the notice is issued to the respondent number 1 by registered post with AD has returned with remark within inverted comma, no such persons, return to sender, inverted comma, close. Stop. However, she appears that the respondent number 1 has also preferred 2 other criminal petitions, that is criminal petition number 18 and criminal petition number 37, which are tagged with the instant criminal petition today. And in those criminal petitions, the respondent number
1 is the petitioner.
is the petitioner and is represented by Mr. M. Vero.
On behalf of IRFE.
M. Vero on behalf of IRFE. In view of the above fact, criminal petition number 52/2024 is directed to furnish a copy of notice along with the petition, along with the criminal petition and annexures to the learned counsel representing Mr. Rajdeep Bhuya in criminal petition number 37/2023 and criminal petition number 18/2023 today itself, during the course of the day. What else?
Lordship, in item number 14 and 15, on the last occasion, this matter was kept in abeyance because one criminal appeal was pending. And it was directed that when the
14 and 15. In 14 and 15, you are the petitioner. And you are the private respondent.
Yes, Your Lordship.
Yes, what is your submission?
Lordship, on the last order, Lordship, 28/11/24. By order 28/11/24, this matters was kept in abeyance because one criminal appeal was pending, Your Lordship.
Where?
28/11/24.
No, criminal appeal was pending before which
Appeal.
court?
Before the Sessions Court, Dimapur, Lordship.
Okay.
So the matter is disposed, Your Lordship. I have the order today, Your Lordship. I'd like to place it before you. To keep on record, Your Lordship.
No, in item number 13, or a line like that. Let this matter be, when can we fix the item number 13?
Any day, Your
For
Lordship.
admission hearing?
Up to 4 weeks then?
Let this matter be listed for admission hearing after 4 weeks. In item number 14, item number 14 and 15 common order hoga. Heard Mr. M. Vero, learned counsel for the petitioner, Mr. V. Zimomi, learned public prosecutor appearing for the state of Nagaland, as well as Miss Esther, learned counsel appearing for respondent number 1, who submits that these criminal petitions were kept in abeyance by order dated 28/11/2024 passed by this court in view of the pendency of criminal appeal number 1/2023 before the Court of London, Principal Sessions Judge Dimapur. Stop. However, she submits that by judgment dated which
6/1/25.
6/1/2025, the aforesaid criminal appeal has been disposed of by the Court of London, Principal Session Judge Dimapur. Hence, she submits that these criminal petition may be taken up for hearing. Stop. Mr. Muazzamir, learned, who was engaged counsel for learned, for whom? He is no longer the engaged counsel for the petitioner. Hence, since he prays that his name may no longer be shown as the engaged counsel for the petitioner in the cause list henceforth, the prayer is allowed. The registry is directed to, what is the item number? Registry is directed not to reflect the name of Mr. Muazzamir as engaged counsel for the petitioner in this case, these cases henceforth. Muazzamir, M. Jemu, M. Solo, and Mane Konyak. With Muazzamir, these 3 names. It is there in the cost list. List this matter after 4 weeks.
For orders, item number 17.
None has appeared for the applicant on call. Let this matter be listed in the next week on a date to be fixed by registry. Unlisted?
No, Lord. Lordship, I may be allowed to make a mention. It appears.
Unlisted after the break. Yes, Mr.
Item 37, my lord, from the supplementary hearing list, which appears to be the topic of by item in that case, Lordship. I am also waiting for hearing item 23, my lord. Here also I am for the respondents.
Item 37.
Yes, my lord. We missed the golden opportunity yesterday.
What is your prayer now?
After 2 weeks, my lord.
Heard Mr. Senti Anger. Also heard Mr. These, who is for the?
K. Angami, my lord.
K. Angami.
Yes, I have his consent.
Learned government.
This is a consensus prayer.
Senior government advocate. On request of learned counsel for both the sides, let this matter be listed after 3 weeks. You have an interim?
No interim, my lord.
After
the sentence has already been suspended by a different application, my lord.
3 weeks.
My lord. Lordship, I may kindly be allowed to peruse the LCR.
Yes. I'm not sure that they will.
Yeah.